Good morning, everybody.
Good morning.
How are you?
Well, hi, Debbie.
Mary, did you by any chance talk to Chris today?
Yes, I did.
Okay, great.
He should be joining anytime.
Okay, great. Thank you.
I should say I didn't talk to him. I texted him. Do people get on the phone anymore?
Rarely, right? Seems like we're trying to avoid that.
Although it is amazing when you do get on a call with a issue or a situation, how much quicker it goes than texts or emails.
Well, January is almost over. 25th of the month already. Hard to believe. Debbie, did you take the picture that you have posted yourself? Good morning, Ruth.
Oh, hi. I'm sorry. What did you say?
Oh, no, I was just asking Debbie if she actually took the picture that she has posted,
Oh,
or if it's just a picture she found.
I
It
see.
looks like somebody actually took a picture on their own.
And I have mine right side up today.
You do?
Mhm.
I'm very impressed, Ruth.
I thought I would have to ask Carlos, but I did it myself.
So Carlos, you can send all technical questions to Ruth now.
Oh, I will.
Morning.
Good morning. Not sure who that was, but
That was Chris.
that was.
I recognized his voice.
Was it?
Yeah, little
There he
computer
is.
issues. I apologize.
That's all right,
Where's your-
Chris. Chris, I'm gonna make you a co-host also.
Okay.
Chris, your camera is covered.
Mine is? Oh, Chris is, yeah.
Yeah, Chris.
I got the cap off.
Huh.
Bit too high, maybe. Do you see anything?
Yeah,
Carlos?
blackness, right? Nothing but black.
What the heck?
Is your video on?
Thought it was.
Ruth, can you give Chris a hand, please?
Sure.
Yeah.
It says it's on.
Just go to the little three dots at the top.
Yeah. Very good.
Call from Home Hospital.
Hello.
Well, in the meantime, while Chris struggles
Good
through
morning.
getting his camera to work, I just quickly this morning, I pulled up the multiple listing service. I was just curious what the available inventory was. So I looked at single family homes and I looked at townhomes and condos. Those are the three categories. So I didn't include co-ops or duplexes, so on and so forth. But interestingly enough, under the status of coming soon, 109 single family homes are available and 38 townhomes and condos in a coming soon status. And then active units for single family homes, 705, this is all of Orange County, and 324 townhomes and condos. So total inventory currently actively listed, well, coming soon and active, 1,176. That's it. So 147 in coming soon status, 1,029 in active status. Doesn't seem like it's changing very much. Then it also appears as if there's greater activity at this time of year simply because interest rates have gone up. I think that the average interest rate now is over 3.5%. Substantially higher. John, maybe you can even tell us what rates are. John Sheehan. Oh, you'll have to unmute yourself, John. I know I didn't warn you in advance that I was going to call your name out. That's right.
Okay,
There you are. Okay, you unmuted.
I am now unmuted, right?
So what are rates today, John?
3 3/8,
Oh, it is. Okay. All right.
750.
A little bit better then.
But 3.5 is not a bad bet.
Yeah. Yeah.
Give you some room. And I'm talking about with zero origination, just underwriting costs and so on.
Got it. And then, Chris, if you're getting closer, let me know. It doesn't look like you are. But
I'm trying. It's saying it's on, and for whatever reason, it's not working. I don't know if there's a cord loose.
Uh-huh. Oh, that's it. You trying to share your screen?
No.
Where's Richard?
Well, Chris, you had sent me the presentation before, right?
Oh, maybe that'll work.
I can probably.
If you need it, Rich, I've got it right on my computer. I can send it to you too.
Oh, you do? Okay, yeah, if you would, Mary, that way I'll just share my screen. Is that you now, Chris?
I have no idea what that is.
We lose them?
Be able to send it, Mary?
Yes, I've sent it.
Okay, thanks.
Maybe he logged off to get back on.
That's it.
Am I muted?
No, you are not, so be very careful.
Okay, because you're in my car. Well, you're not, but you might hear Jay start to snore. It's not me snoring at the meeting, but he's been working all night.
Well, Chris, I've got the presentation. Do you want to, are you logged in?
No.
Can anyone see my screen now? It's entitled Common Types of Trusts.
Yes.
Okay, great. So
I can
Chris,
see
if
it.
you're there, I can just go through the presentation.
Okay. And you guys can hear me fine. The audio is working, right?
Yes, we can.
Okay. I don't know what happened with the camera. It says it's working, but I'll get that worked out. I apologize for the technical errors, but in a recent meeting with Richard and I, we kind of were talking about what we're seeing out there, and quite frankly, if it's not fraud, it's death. It seems like we are dealing with various types of trust or probates, and so that's what we're going to kind of cover here today. This is kind of taken. This is taken from some training I do with our title units. So what I wanted to do is just kind of go over some definitions, kind of put you in some real situations and what we're seeing. And then after we get finished with the trust, we'll just go into a quick little presentation on the probates as well.
Okay, Chris, I'm sorry, I should have introduced you. By the way, this is Chris Aiken. Chris is Vice President, Lawyers Title and Title Operations Manager. Chris has succeeded Glenn Auerkamp in Glenn's former position. And Chris
Thank you.
has, what, 25 years of experience or so?
A little over 30,
Okay.
Been doing this a long time.
Didn't mean to cut you short, but so now we know Chris. Chris is available for assistance if we ever need assistance, by the way.
Absolutely, I look forward to it. I enjoy unlocking these so we can move on to close. So if you ever run across any of these instances, please don't hesitate to reach out to me. So beginning, our common types of trust that we deal with on a pretty much daily basis is the inter vivos trust, which is our living trust. Generally, you're going to see that that's created by husband and wife, or maybe it's an individual. And they'll be broken into two different categories, either the revocable trust, which gives the power of the creator to amend that trust. They can restate the trust, and it's a far more flexible trust. There are instances that upon the death of a creator of a trust or of a trustor, that becomes irrevocable. So generally we look for that when we're reviewing trust. An irrevocable trust is exactly how it sounds. The trustor creates the trust. Once it's finalized, the trust can't be changed without the consent of the beneficiaries. Depending on the trustor, how aged the trust is, this could actually go to court as well, especially when we're dealing with multiple named successors that are deceased or incapacitated. And then finally, the testamentary trust. We run across this maybe twice a year. And this is when there is a provision in a will that appoints the trustee to manage the assets of the deceased. This trust, however, does have to go through probate court. So on your second slide here, one of the most important things that we look at whenever we're getting a legal vesting or, we do our prelim is we want to make sure that the entity holding title is an entity capable of holding title. And that means a trustee or the administrator of that trust must be set out. You'll see here in the example, John Smith Living Trust. Well, we don't know who we're dealing with. We know that there's a trust involved, but it's very important that we know who we are dealing with because it will dictate how much a title company is going to require to, get into a comfortable position to go ahead and insure. And the next two examples, they're correct. So as long as the trustee is set out, be it in the first of the vesting, John Smith, trustee of the John Smith Living Trust, or if it's the John Smith Living Trust, John Smith trustee, those are correct. We know we're dealing with John Smith as the administrator of this trust. And in certain instances, refinance, we may have to get a correction deed if it's not correct. Generally with sales, we can always do who acquired title as, and we can fix that. But that does generally affect what we may ask for, a copy of the trust in addition to a trust cert.
Chris, this is Mary Guac. Hi.
I can see you.
Okay, good. Can you give us a high level on when we would need just a trust cert and when it becomes necessary to see the actual copy of the trust? That's a common question that I
I
get.
sure will.
from my
It's coming up,
agents.
actually.
Oh, awesome.
I'll move on.
Third one. Okay, so again, the trustees, that is who manages the assets conveyed to the trust. We're more concerned with the real estate assets, obviously. Married couples are often trustees of the trust. When one dies or becomes incapacitated, generally the surviving spouse will continue in their capacity as the trustee. When we have a co-trust serving as the sole surviving trustee, we may ask for some evidence if the trustee is deceased, if they are incompetent or incapacitated. We may need to get a statement from the trustee's doctor as to who is empowered in this situation to be the successor trustee to carry on the wishes of the trust. Richard, you can go to the next one.
All right.
So generally speaking, John Smith Living Trust is our record title holder. John Smith has showed up at the office and has enlisted you to sell the property. We are only going to require a trust cert. So the general rule of thumb is if the record trustee is the one that is conducting business for the trust, all we're going to require is a trust certificate. The trust certificate for title companies is extremely powerful. It gives us the information that we would normally get by reading a trust. We're going to get who the trustee is, the trust powers. It's signed under penalty of perjury, and California law has held that if they are providing fraudulent or false information, that we are not going to be held liable for that. We call it our safe harbor. We will require a trust cert anytime there is a trust. If it's a seller, we're going to ask for the trust cert. Even if we have to review the trust for that seller, we're going to ask for that trust cert prior to close. If it's a buyer coming to title as a trust, again, we're going to have the buyer supply us with a trust cert. If we do find that the record trustee is not John Smith, in that situation, then we're going to require a copy of the trust. And what we're looking for is we want to make sure that we are dealing with the successor trustee, the proper successor trustee. I wouldn't say there's a ton of fraud with that, but a lot of people just don't understand the process, and maybe the person listed as the second successor trustee is doing all of the business. They're not empowered to do that. So we have to make sure that we do have the right person in the right order that was listed in the trust. Slide 5.
Before you go on though, see, when we talk about the purchase agreement that we use, the mandate is subsequent to execution of the contract, that whomever is signing in the capacity, for example, the trustee has an obligation to provide documentation that they have the authority to act on behalf of that entity. So from your perspective, then we would possibly need to evaluate if it is the successor trustee or the trustee of record who is executing the purchase contract. And we theoretically could ask for a trust certification or provide a trust certification as meeting the requirement contractually, or we could even go to the extent of asking for a copy of the trust.
Right,
So-
and a lot of times what happens is we get a copy of the trust prior to the property being listed, just to make sure that in fact the listing agent is dealing with the proper person that has the power to act for the trust.
So you have listing agents that make that request of you to verify whether or not the person they're speaking to or who's going to sign that listing contract is
Correct.
indeed the person with authority.
We do it all the time. Just a service we provide, saves us a lot of time down the road getting closer to closing, because we already have a copy and we know who is empowered to act for that trust.
All right.
And it
So
also keeps the listing agent out of, having to go back and
yes.
do a whole nother contract with the right person.
So your evaluation is it's simply looking at the last grant deed to see who the trustee of record was associated with the vesting, and comparing that to the trust cert or the trust documents themselves.
Exactly. We'll take the last deed of record. The question is simply, is this the person that is signing the contract? Yes, then, they're empowered to act for the trust. We'll get a trust cert, escrow will get a trust cert during the process of the sale. But if that person is not the one that has presented themselves as the authority for the trust, then we will ask for a copy of the trust.
Okay. And keep in mind, if we're taking a listing contract and it's somebody and the property is vested in the trust, I mean, first of all, you should be making that determination before you even draft a listing contract. But you can actually then verify the information yourself. You can look at the last grant deed, right, when using property profile to determine how the property was vested. So if it's the Richard Moore Family Trust and I'm the one claiming to be a Richard Moore signing, then you should feel confident going forward that I actually have authority. But if it's somebody else who's signing that listing contract, they may not actually have authority. If the vesting on title does not match the person who's signing that listing contract, likewise for a purchase contract. I think it's rare that we ever ask for a trust cert when we're taking a listing or signing a purchase or having a purchase contract executed by a buyer. I'd say we probably never do that. We may ask for the trust documents, so that's fine also. I'm sorry to interrupt, Chris.
Oh, no, it's fine.
Do we have questions about any of that before we move on to the next slide? I don't see any. Okay. Great. If you'd continue, Chris, next slide.
Okay, that'd be slide 5. Okay, so this is kind of what we're doing. A lot of people are intimidated by a trust because there's many variations in the trust size and detail. If you are in fact going to require a trust, most trusts have a table of contents. It's just like a book. You can find exactly what you need to go find. But here's what we're doing when we are verifying a trust. We have someone that has presented themselves to your office that is not the record trustee. So we want to, first of all, look at the trust. We want to ask the question, what happened to the original trustee? And then we will find the provision that deals with that eventuality. If the trustee is deceased, obviously we'll get a copy of the death cert. If he's incapacitated, we're going to review what is the provision for incapacitation. Like I said, sometimes it's a doctor's letter, sometimes it's 2 doctors' letters. And we'll need to get 2 doctors that will, on their letterhead, state that the person is incapacitated, under their care, is not able to handle their own affairs. It's a couple of word sentence. It doesn't have to be anything complicated. I can tell you, I've had their entire medical file sent to me. I've just flabbergasted by that. I don't need all of that. We're not doctors. All we need to know is that, yes, in fact, they are incapacitated. And then we are going to review that trust and find out who's the first successor trustee in the case of the incapacitation. Some are a little wonky, and while they're alive, this guy will be the trustee. If they're deceased, this guy will be the trustee. We just verify that, so that we know that when escrow creates the vesting deed out, they are listing the proper successor trustee. And it also gives you that comfort that you are in fact dealing with the person that's empowered to list this property and sell it. So those are the things that we look at.
Yeah, Alex has a question. Is it a standard form that's provided by the trustee, or do we provide the form and ask them to fill it out? Usually the trustee is probably not going to have a certification of trust, so it's something that we can provide them, Alex. And yes, it is a standard form that everybody relies on in terms of certification of trust. Or likewise, if you have any concerns in taking a listing or having a purchase contract signed, you should ask the buyer at that point in time for evidence of their authority before you move forward. Now, for example, the listing contract specifically states that we're entitled to rely on the representation that they have authority. But I can assure you from past incidences, we have not been able to rely on the person that signed a listing contract, and maybe they only had partial authority. It may not be a trust, but it's happened more so with an LLC or a corporation who actually has authority to sign on behalf of those entities, especially with an LLC, which is very common. And there could be multiple managers or members that are required to sign any type of document to sell or acquire property. So hopefully that answers your question, Alex. If not, you can speak on up. Good question. Next slide, Chris.
Yes, sir.
Okay.
So these are the red flags that we look at, and this is the red flags mean that we've suffered some sort of fraud, and that's why we call them red flags. It's not every instance, but it's occurred enough that if we're presented with something like this, that this is kind of what we're looking for. A lot of times when we are not dealing with the record trustee and that trustee is still alive, maybe he's incapacitated, maybe he's had a stroke and is unable to sign. We have run into those instances. We'll be presented with a power of attorney. We rarely, if ever, will accept a power of attorney when there is a trust involved, simply because, generally speaking, the trust doesn't have a provision for a power of attorney. They set out their provisions if the initial trustee cannot act, and they prepare for an eventuality of death or incapacitation. We just follow those rules. So that's why, generally speaking, we don't take the power of attorney. And I can tell you probably 9 times out of 10, the power of attorney, the person who has that power of attorney, is listed as a successor trustee anyway. So it's really no big deal. Again, with the incapacity of the trustee, the big thing here, and the reason why it's shown a few times, is there's a lot of pushback because the trust calls for 2 doctors. We have no idea why the original trustee has required 2 doctors. We don't know the family dynamic. I don't know. But if they ask for 2 doctors, then we need to get 2 doctors that are attending to the patient. And if they're in a home, there's going to be a couple of doctors that see them regularly on rounds that we can get the doctor's letters from. And again, it doesn't have to be anything formal. A couple of sentences attesting to the fact that they are in fact their doctor and that they cannot handle their own affairs. Unsigned trusts, it's just pieces of paper. We'll get to what we can do in those cases, but if they cannot provide us with a signed trust, then you're looking more that if they're deceased, you're probably looking at a probate procedure. And then finally, and we run across this a lot, in the state of California, land trusts are not recognized. At least we cannot insure in or out of a land trust. It's simply because the fiduciary duties of the trustee are not clearly set out. The beneficiaries are susceptible to legal challenge, and there's a whole lot of risk that we just don't want to take on with land trust. There are ways around it. They can deed out of that land trust, and then we can clear the individuals and move forward. But as a general rule of thumb, we do not deal with land trusts.
Okay.
And
so
then the
let's go
final
over-
slot, yeah.
I'm sorry, let's go over some of these bullet points, the power of attorney. So unless the trust documents give authority to somebody via power of attorney, but if it's not specifically stated, power of attorney is really going to have no validity or effect, correct? But it's possible the trust documents could give authority via power of attorney. It's just a rare circumstance that we would find that in the trust documents. Is that fair to say?
It's fair to say, and it's a red flag because you have sat down and with your estate attorney and you've created this trust and you've prepared for every eventuality. Why did you need to back that up with a power of attorney? Is there elder abuse involved? And these are kind of the things that we're thinking of. That's why we will generally rely on that trust to dictate how to move forward.
Okay. And then in terms of authority to act on behalf of the trust, the trustee has the ability to act, right? Or the authority, they can relinquish their authority. And this is a question that comes up often. And for whatever reason, they want to relinquish their authority and assign that authority to someone else, a successor trustee, to act on their behalf. So what do you typically require in terms of an amendment to the trust that you would believe to be a valid document? Does it need to be notarized, just witnessed? Anything like that? If I assign my authority to my son to act on my behalf, if he was listed as a successor trustee, and I'm just simply relinquishing my authority for this transaction. So what do you need to see?
Again, we're going to follow the provision in the trust that prepares you for that eventuality. There could be, the resignation must be in writing to the successor trustee, and generally the attorney will draw up a document, or maybe they just draw up a document themselves together, but both parties, one party will resign, the successor trustee will sign as accepting the position of successor trustee. A lot of times they're not notarized or anything like that. We have the ability to check the trustee's signature, obviously, but there'll be a provision. And again, there's some are really complicated. We just follow what the trust says. If there has to be something in writing presented to the beneficiaries, we're just going to ask for a copy of that. If has to be an amendment, then we're going to ask for a copy of the amendment appointing the new successor trustee.
Okay, so people from our office, they're presented there, and this happens often. The person that's claiming to have authority says, "Oh, I've got a power of attorney," and that we know that that's not going to be acceptable. What they can obtain is just written authorization from the trustee giving them authority. Let's assume they're the successor trustee, to act on their behalf for that specific transaction. Once again, there is no special document. It doesn't have to be recorded. It doesn't have to be notarized necessarily, correct? It's just really a simple one-page instruction relinquishing authority and assigning authority.
Correct.
Okay. So hopefully that helps as you encounter some difficulty with individuals when you're trying to move through a transaction. Then are you going to address the Hagstead Act also?
Slide 7.
Okay. Did anyone have any questions? We have something in the chat box. And
I
then
have a
Debbie, good question.
I have a
almost skipped
question for
over it.
Chris.
Go ahead.
Chris, as far as the resignation goes, if the trust doesn't say anything and I wanted to resign as successor and name my brother to take over the responsibilities, but he's not mentioned in the trust, how would we view that? I just had something like that come up. So it's not someone that's mentioned in the, how there's succession in a trust, like this person's a successor and then after that person is this person, but can we view that type of reassignment even if that person's not named in the trust?
That gets a little dicey.
Okay.
What's the condition of the original trustee? It's quite possible that maybe the third daughter doesn't want to do it, and there is a younger son, and maybe the trust was drawn when that son was a minor.
Mhm.
If the trustee is signing off on that resignation and then appointing or amending the trust and specifically amending that successor trustee clause, then we'll accept that. But again, it depends. if you're dealing with a trustee that's deceased or incapacitated, now it gets a little dicier.
Thank you.
All right. And then, Chris, can you briefly explain what a land trust is?
A lot of people, not briefly.
We have time.
It's a trust that's set up that really, it's a trust in name only. And the problem that we have is it's so difficult to verify anything. So you will see these as the 4215 Main Street Trust. That's a tip to us right away. Okay, we're probably dealing with a land trust. It doesn't really provide, when we get the paperwork, it doesn't really provide what the trustees' powers are. And the beneficiaries are often blind beneficiaries. We don't know the succession to the land trust. Now, that's not to say the 1542 Main Street Trust couldn't be a real honest to God trust, but that's what they generally look like. So there's just things in the documentation that we receive that's not written like a trust. Therefore, we can't verify the specifics that we need for power and authority to act for that trust.
So, Chris, isn't it true that most land trusts don't have an actual taxpayer ID?
That is possible, yes.
So, from our perspective, or when you're representing the buyer has an obligation to obtain the taxpayer ID. Otherwise, the buyer has an obligation to withhold for the IRS and from the Franchise Tax Board. So, what have you encountered in circumstances like that when there is no taxpayer ID?
For me,
Yeah, and do you have any issues with that?
we generally don't get that far. I wouldn't, because I don't really handle the money. The taxpayer ID isn't really a big thing for us. Ours is the authority. So the documentation provided, we wouldn't even get that far. We would know from the documentation provided that we can't continue with this unless there's some adjustments made to how title is going to be held,
Yeah.
or how title will be taken.
So from our perspective, everybody, if we're representing a buyer, remember the buyer has an obligation to obtain taxpayer ID. Now, we can rely on the representation that whatever number they give us is accurate. However, if we're aware that it's false, that's another issue, and the buyer has an obligation to withhold. Also, escrow typically will be the one who's managing that and remitting the withholdings to the appropriate entity. But and then the other thing, it seems like in many cases, land trusts are used for, it's almost like an entity that doesn't exist. It's just something on a piece of paper. And I'm familiar with one case right now, which there was a land trust, and it was used in some capacity to swindle a woman out of her property. And now there's a quiet title action against the land trust, but nobody can be found associated with it. So I think that's probably why title companies are hesitant to insure transactions in which land trust exists. It's trying to shield anybody else that could be associated with it, so it seems.
A lot of times they could be shell companies for offshore entities or interests too, which are, always a red flag for fraud.
Yeah. Okay, any other questions about that? Yeah, Debbie, got that? All right.
So finally, we probably hear this on a daily basis. And this is where it happens most often. A trust is in title and the trustees decide to get a reverse mortgage. The lender will not accept the trust as the record title holder, so they deed to themselves individually. They take out their reverse mortgage, and then for whatever reason, be it there wasn't a deed done at the time of close, the attorney forgot to record the deed, or the parties forgot to record the deed. If the two trustees are deceased, still holding title as individuals, then obviously it has to go to probate. However, if it can be proven under the Hegstead precedent, we call it the order, the trust attorney can petition the court to look at the documentation they have that shows that this property should have been in the trust and should have been a trust asset. And they can issue an order granting the property to the trust. We'll get a certified copy of that order, and then we're able to divest title from the trust. The biggest question I think I get asked about this is, how long does it take? You're looking at about 120 days to file the petition, have the case heard, and have the order issued. And that's been pretty close to, with COVID and all, that's generally how long it's taken. It's around 120 days to get the court to issue the order so that we can record, and then we can divest the title from the trust.
Okay. Any other questions before we move on to the probate section? All right. Let's try this now. Okay, Chris, I think I've got the probate section showing.
Okay, I can see it.
All right, great.
All right, so this is where we don't ever want to go, because this is time consuming. A lot of documents have to be obtained. There are appeal periods. So what we'll do here is we're just going to kind of go through some of the stuff. Again, looking at definitions and kind of what we're going through, what we're going to require, what we can do to avoid some of the appeal periods. So obviously the probate is going to be used when the record owner dies and there isn't a succession of ownership. It wasn't held as husband and wife as joint tenants. It wasn't sole survivor or right of survivorship. The property wasn't in a trust. So obviously that property has to go to probate. I lost my screen. There you go. So the second
Screen.
slide there, Richard, please. So here's some of the definitions, and obviously the probate is the legal proceeding which a will is reviewed by the court to determine whether it's valid and authentic. And I put that in there because for whatever reason, we're seeing more and more legal opinion letters from attorneys that state that this is a valid will and it's authentic. Well, that's the argument they need to make to the probate court, because the probate court is the only person that can tell you if it's valid and authentic. The attorney opinion letter, that doesn't work. What the probate court is also going to do is they are going to make sure that there is supervised administration of the deceased estate. They're going to appoint an executor or an administrator or a personal representative, and that's their responsibility to collect the decedent's assets, pay any claims or liabilities, and then finally distributing the assets of the estate to the devotee that's named in a will or an heir if there is no will. And again, a devotee is a person who is given real property under the provisions of a will. You might see a prelim that says the heirs and devotees of. On that prelim, we don't know yet because we haven't collected the documentation if we're dealing with a will or not, and that's why we put them both. Intestate is a person who dies that does not have a valid will at his time. And so the court is going to take over to find an heir of the property. They'll start with the decedent spouse, minor children, adult children, and they're going to keep going until they find an heir to this property, maybe the decedent's parents. And then finally, the testator is the person who makes the will and directs how his or her property will be distributed.
Okay.
Now, there can be a court-ordered sale, and that's either with a will or without a will. And in this case, the court will authorize the sale of the property. There's going to be an executor's deed. And then what happens is the property is sold, just like any other real estate transaction. The liens are going to be paid, and then the heirs or the devotees will receive the sale proceeds remaining after all the debts have been paid. And that's a court order sale. We call it the executor's deed. Inheritance taxes, there are federal and state inheritance tax. In California, there is no inheritance tax, but you can be taxed for receiving property through a probate, a gift. I believe the threshold for that is anything over 5.4 million. For the most part, we don't see a lot of this. However, if you own property in California and maybe you died in another state, that could affect you depending on what your role is as the heir. And we'll get to this a little later. California property has to be probated through California, but we'll get to that and what we can do on the next slide here.
Okay, Chris, I've got a question going back to trust. So in the event let's assume it's a husband and wife and the property's in the trust, there's right of survivorship. So what must the surviving spouse do to have authority to actually convey or sell the property? So what documents do they have to record? An affidavit of death, and to do that, they must have a copy of the certified death certificate. Is that correct?
Correct.
All right, so anything else that they must do, because we have people, it's occurred unfortunately, and they're not sure what they need to do initially to even put the property in the position for them to sell that property. So that's just it, the affidavit of death and the certified death certificate, correct?
Correct. And
Okay.
then the trust will probably name them as the surviving successor trustee. So we just need to take care of that decedent's interest. At the very least, with a death cert, we do like to record the affidavit with the death cert, so that
Okay.
the record reflects it.
And is there anything similar if it's a probate sale that must be recorded?
Yes, there are documentation that we will require depending on the type of probate and what we're doing.
Any other questions about that before we move on? No? Okay.
So when a decedent's property has been conveyed by the executor or administrative personal representative deed, we're going to look at this as any other deed, but we do have some requirements. The deed must be signed properly. So it has to be signed by the estate representative in their capacity. For example, I would sign Chris Aiken, executor of the estate of John Doe. John Doe doesn't sign because he's the deceased person. So we want to make sure that that's there. And also the executor deed must refer to the court order authorizing the executor to sell the property. So it would read Chris Aiken, executor of the estate of John Doe pursuant to that court order case number, and then that would be reflected. In the cases where we are dealing with an administrator that has letters under the full independent administrative powers, meaning they have full authority, then a court order is not required. And we're going to go over some of these documents here in the subsequent slides. We want to make sure that the estate and interest is conveyed completely matches the decedent's recorded interest. And I cannot tell you how many times that gets messed up. So we have to make sure that, if they only owned half an interest, that's all they can have and convey. We get into some trouble with that, the things that are recorded prior to us getting involved. The estate representative should not convey to him or herself individually. Generally, if that happens, they're probably not following the letter of the court instructions. They cannot accept a purchase money deed of trust like a seller carryback. And the sale of the decedent's property does not eliminate federal estate tax lien if it qualifies. So those are some of the things that we're looking at with an executor's deed. It's not something we see a ton of. Generally in the following screens, these are the more prevalent that we see.
I just want everyone to know I'm not the one drawing those blue lines on the screen.
I'm not either, because
I'm not sure how that happened, but
It is so bizarre.
yeah.
that is funny. So letters of administration, you hear us probably, or escrow, just call it letters. That is given by the court to the personal representative, be it an executor, administrator, or personal representative. The letters are going to reflect the name of the decedent, the court of jurisdiction, and the case number of the probate proceeding. And the letters will reflect the authority given to the executor or administrator. And boy, that's the first thing we look at, because it's a slam dunk if they have full authority. That means that's it. After they have filed the paperwork necessary, they've been given full authority to act for the estate, and they don't have to go back to court to do anything. If they are given limited authority, then in that case, they will have to go back and get an additional court order approving whatever they're going to do. And that could be a sale. I have run across a couple of loans. The estate needed to take out a loan to pay off some matters prior to selling the property. The court has approved that. So the letters, we will always ask for a certified copy so that we can record that concurrent with the grant deed to the ultimate purchaser. Mentioned here is the jurisdiction and the case number of the probate proceeding. And I want to be clear here, California property has to be probated by California probate court. That's not to say that I die in a different state, my estate is probated. What happens is California will just issue an opinion agreeing to that probate, but it has to go through that process. So we don't see a lot of it. You know, that's one of those 1 or 2 times out of the year that just causes us all grief because this sale needs to go. And but the California court must approve by joining in that other state's probate proceedings.
Okay.
And again, this is a little more wordy version of what I just kind of went through. The Independent Administration of Estates Act. And again, you know, the court approves the authorizing of the administrator to sell the property. And if they have full authority, then they're able to go ahead and do it without going back for a court order. If they only have limited authority, then we also have to go back, get that court order. Generally, we will want a certified copy of that court order to be recorded as well, because that verifies the limited authority has been superseded by the court order.
Okay,
And then
fine.
on 7.
All right.
So here's how it works. You know, the court is going to appoint this personal representative, and then the representative is going to move to have the property sold so that the heirs and devasees can be paid off. What they have to do is they have to file what is called a notice of proposed action. The notice of proposed action goes out to each one of the heirs and devasees, and it has to go out 15 days prior to the proposed sale. That 15 days is important because they have 15 days to object to the proposed sale in writing. If they do not object, it is assumed that they approve the sale of the property. But we have to wait that 15 days. There's an appeal period. That's the appeal period, basically. So what we do is we'll either get a copy of the return notices, or if there has been no objection, there's only one beneficiary in a lot of times, then the attorney can send us a letter stating there have been no objections to the proposed sale, and we can go ahead with our certified copies of the letters and close. But just remember, the notice of proposed action has to come first so that the heirs and devasees can approve, or they can object to the proposed action. After that 15 days, or if there are no objections, we can go ahead and close with letters with full authority. And then the last slide, I wanted to point this out because we run into this not as often as we used to. People have gotten a little more savvy with their estate planning, but the decree of distribution, this is when someone has a whole bunch of property. They've died either intestate or testate. The court then steps in and they are going to dictate the distribution of the real property. And it could be that this is one of those cases where the heirs are just hard to find, and maybe they need to split it up or whatever. But one of the most important things in the decree of distribution is what we call the omnibus clause. A lot of times we'll run a property, we'll find out that the person that holds title is deceased, and we'll ask, was their estate probated? And we'll get the documentation, and if the property isn't listed, that's the first thing we're going to look for. Is there the typical omnibus clause in the decree of distribution? And what that states is all other property of said estate, whether described herein or not, is hereby distributed as follows. And then we will follow that decree. We'll get a certified copy, obviously. We'll get it recorded on our property, and that in effect transfers the title to maybe the person that is representing themselves as the administrator of the estate, or the person that is the true owner of the property. So the court rendering the decree of jurisdiction, it must have jurisdiction over the parties in real property. Again, would have to be a California probate court. The decree is final and non-appealable, and generally speaking, if it's run its appeal period, it's non-appealable. Generally, we run into this more times than not. The person's been deceased for a while, and the person that was granted the property, or the individual that were granted the property by the decree, are just moving through the property. So it was so long ago, we don't have to deal with appeal periods. But we may have to review the court case. Generally speaking, a certified copy of the final decree of distribution gives us everything that we need. And if the property isn't listed, we still have that omnibus clause that we can refer back to. And that, in short, are some of the things that we look for in a trust, or if unfortunately we've got to wait out a probate proceeding.
Okay, there's just something I'd like to bring up to help everybody get a clear understanding. You're going to see this form that's sitting on my screen. Just a blank form. It says attorney or party without attorney. Everybody see that? It's a form DE-111. Okay, great. So you've heard Chris talk about letters, testamentary, letters of administration. Well, I think this will help maybe give you a better understanding of what that is. So when someone dies and there isn't a trust and there's a will or no will, this form, it's a petition, must be filed with the court. So you can see it shows the estate of, and it shows the name theoretically, right, of the decedent. And then the petitioner is going to check the box. If it's a probate and they're searching for a will and letters testamentary, or will and letters of administration. So the executor or executrix or the administrator or administratrix, those are all deemed to be the personal representatives. So personal representative is a term that describes both an executor or a court-appointed administrator. And then also Chris mentioned under authorization to administer under the independent administration of the Estates Act. So you can see that last block, and I've tried to highlight that. So in the event there is a will and it doesn't preclude full authority, then the petitioner can ask for court approval to sell the property without it going to an overbid process or without it requiring court approval. Limited authority always requires court approval, so keep that in mind. And I think the question comes up, if there is full authority and nobody has contested the executor's authority, or then they don't have to go to probate, to a court approved sale. And let's assume that you don't have full authority. The overbid process, it's somewhat simple. Everybody's during the process in which the property is actually held for sale, you submit an offer as you normally would, and then the executor would choose the highest and best offer ideally. And then once the court date is scheduled, the judge is simply going to review the offer. And then in addition to that, they're going to open it to overbid. And the overbid is going to be the first bid must be equal to 5% of the first $10,000 of the selling price, plus, 10% of the first $10,000, 5% of anything over the initial $10,000 of the selling price. Then after that, if somebody does submit that bid, then the judge determines what each successive bid will be. But typically, the other questions that come up, if a property is being sold and it's subject to probate, people think that I must get a 10% deposit. Well, state statute does not require that. You can accept a 3% deposit. You can do that if you're managing the estate. However, the court at the overbid process, if there's a successful overbidder, they're probably going to demand 10% deposit at that point in time. And most likely, a court is most likely not going to accept an offer that's subject to financing unless the executor or administrator agrees in advance that they would agree to move forward with an offer that contains financing. So once it goes to court, it seems like most likely the court is not going to approve a bid that is anything but cash. Just keep that in mind. And does that help when you look at this, when you hear about letters testamentary and letters of administration? This is what title is going to expect to see. It's going to be the filed copy and the results of this petition, whether or not it has been granted or not. Anyone have anything else they'd like to add or questions that they have? No, there's something in the chat box. So many young people don't have wills or trusts. If the deed shows that they are joint tenants, does it still have to go through probate if the successor wants to sell? So if it's community property with right of survivorship or joint tenancy with right of survivorship, does that avoid probate, Chris? And there's no will or trust?
Yeah, for the first person, the first spouse to pass away, yes, then there's a natural succession of title, and the surviving spouse will have title to the property. Just have to record the proper affidavit of death. And with right of survivorship, they obviously get a significant tax break as well.
Yes. And keep in mind, in regards to the tax break he's talking about, if it's joint tenants with right of survivorship, there's a step up in basis of 50% of the value of the property. But if it's community property with right of survivorship, it's 100% step up in basis.
Yes.
So in today's world, it doesn't seem as if there's any reason for a married couple to not hold it in any other way except community property with right of survivorship.
Richard, that's such a great point. It's still amazing how it's underutilized amongst married people. I think a lot of times agents kind of forget that that's an option. Not that we're supposed to be giving vesting advice, but there's still a lot of people. I mean, that's really a great call to action for some of your past clients too, is checking to see how they're holding title and getting them moved over to community property. The other thing is with trust, especially this day and age and last year, where so many people refinance their homes, and sometimes they refinanced as individuals. So they came out of their trust and then they don't put it back in. So that's another great call to action when we're looking at making calls to our clients and past SOI.
Yeah. If you notice your clients have refinanced, check title. It's real simple to see exactly what they've done. Good idea. And likewise,
We
when
can
you're
see you
checking
now.
to see how the property's vested. What was that, Carlos?
We can see Chris now.
Yes.
Yeah, I figured it out. I'd rather not say what was wrong. So,
Sounds like operator error to me, Chris. It's just
yeah,
a
let's
guess,
just keep
right?
the illusion that I know what I'm talking about. All right. And then, I apologize.
Well, it's good to see your face, Chris.
I appreciate that.
Okay, any other questions before we end the meeting? Nope. Okay. Well, hey, thanks for attending, everybody. I hope you liked it. I thought it was great. Thank you, Chris. Excellent.
Thank you. I appreciate it. Sorry about the camera.
No, that's okay.
Thank you.
Bye, everyone.
Thank you.
Thank you.
Thanks, everybody.
Bye.